Today on Legalese, we are going to be talking about the death of Chevron deference. Hey, greetings everybody, and welcome back once again to Legalese. Now, as always, I am your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me especially welcome you. This is the podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, I just want to remind you guys real quick, if you want to find out more about the show, you can go check out our homepage over at legalespodcast.com. And if you want to make sure that you always stay up to date whenever I post new content, all you have to do is go sign up for our newsletter over at legaleshow.com, because I don't just put out videos like this here on YouTube. I also do an audio-only podcast version of the show over on Spotify, and I post articles all the time over on Substack. So if you want to make sure that you get updates whenever I put out any new content, no matter where or what it is, just head on over to legaleshow.com, subscribe to our newsletter, and you will get notifications for all of that. Now, we have a lot to get to today, so let's just jump right in. And I know I tend to say that at the beginning of just about every show, but today we really do have a lot to get to, and I'm really excited to get to it, really. This is going to be a very interesting show as far as I'm concerned here. Now, this all revolves around the fact that on January 17th, the Supreme Court heard oral arguments in two of the most important cases for this term. And these are both cases which will have major implications for the future of the administrative state and for the Chevron Doctrine. Now, the first of these was Relentless Incorporated versus the Department of Commerce, and the other was Loper Enterprises versus Raimondo. Now, back in October, I made videos for both of these cases as part of my annual Supreme Court Roundup, where I pick some of the most important and most interesting cases for a given Supreme Court term, and we do a real deep dive into every aspect of the case. And so back in October, I made videos where I introduced people to these cases as they were going to be coming before the court this term. However, additionally, Loper is actually a case that I have been following for some time, ever since it first came before the district court. And so I have a number of videos going back a couple of years covering that case as well through the lower courts. And so if you want to find any of those past videos about these cases, you will find links to all of those on the show notes page for this episode. Now, there have been a number of fascinating and important developments that have come about as a result of the arguments that were just made before the court. And this case has really only gotten more interesting and more exciting over the past couple of weeks, which is what we're going to be discussing here today. But first, I think we should probably do a brief review of the background as far as what Chevron deference actually is, and we will also be talking about the facts of these cases.
Frequently, an issue of this sort will come before the court clad, so to speak, in sheep's clothing. The potential of the asserted principle to effect important change in the equilibrium of power is not immediately evident and must be discerned by a careful and perceptive analysis. But this wolf comes as a wolf.
Now, while that very famous quotation that I just played actually comes from Justice Scalia in his great dissent in another case, Morrison versus Olson, I really can't help but feel that it is in many ways a perfect description of Chevron versus National Resource Defense Council. Now, one of the most important principles in administrative law is Chevron deference, which was coined after a landmark case, which was Chevron USA versus the National Resource Defense Council in 1984. And Chevron deference is referring to the doctrine of judicial deference given to administrative actions. And in Chevron, the Supreme Court would set forth a legal test as to when the court should defer to the agency's answer or interpretation, holding that such judicial deference is appropriate where the agency's answer was not unreasonable, so long as Congress had not spoken directly to the precise issue at question. Now, the scope of Chevron deference and its doctrine is that when a legislative delegation to an administrative agency on a particular issue or question is not explicit but rather implicit, a court may not substitute its own interpretation of the statute for a reasonable interpretation made by the administrative agency. And rather, as Justice Stevens wrote in the Chevron case, if the statute is silent or ambiguous with respect to the specific issue, the question for the court is whether the agency's answer is based on a permissible construction of the statute. Now, the court's decision set forth a two-step analysis for federal courts to use when adjudicating a challenge to an agency's interpretation of a law, and it is this two-step analysis that has come to be known as the Chevron Doctrine. So, when it comes to the Chevron Doctrine, according to the actual case, Chevron itself, first always is a question whether Congress has directly spoken to a precise question at issue. If the intent of Congress is clear, then that is the end of the matter for the court as well as the agency, and they must give effect to the unambiguously expressed intent of Congress. If, however, the court determines that Congress has not directly addressed the precise question at issue, the court does not simply impose its own construction on the statute. Rather, if the statute is silent or ambiguous with respect to the specific issue, the question for the court is whether the agency's answer is based on a permissible construction of the statute. And so, at the first step, the Chevron Doctrine requires a court to evaluate whether a law is ambiguous. If the law is unambiguous, then the court must follow it. However, if the law is ambiguous, then the court must proceed to step two. And at step two, the Chevron Doctrine requires the court to evaluate whether the interpretation of the law that the executive agency proposes is reasonable or permissible. And if it is, then the court must accept the agency's interpretation. If it is not, only then may the court conduct its own interpretation of the law. And with that background of Chevron deference itself, let's move on to talking about the Magnuson-Stevens Act. Now, for the past 30 years, the Magnuson-Stevens Act has given the National Oceanic and Atmospheric Administration, also known as NOAA, the authority to require monitors on commercial fishing boats. Now, these monitors are intended to ensure that the fishermen adhere to ethical fishing practices as mandated by NOAA. And the MSA explicitly requires the owners of certain classes of fishing boats to pay for their own monitors. However, the MSA does not specify who is responsible for paying the cost of the monitors on herring boats used by the fishermen. Now, the fact that the Act explicitly says certain classes of boats must pay for their own monitors, but does not include herring boats on that list, makes it clear that Congress did not intend for the herring fishermen to pay for their own monitors. And in fact, for many years, NOAA agreed with that interpretation, paying for the herring boat monitors themselves. Now, during that period, the herring fishermen working for Relentless and Loper were happy to host the monitors on their boats, but then something changed that put the fishermen's livelihoods at risk. And with this, we get to the background of the two cases at issue here, which are Relentless Inc. and Loper Enterprises. So this issue began when the government recently ran out of money to pay for certain at-sea monitoring programs. Now, instead of asking Congress for more money, NOAA suddenly decided that the herring fishermen must now pay for the cost of their own third-party monitors. Now, these monitors are paid more than $700 per day per ship, which can be as much as 20% of the ship's daily take-home pay, and in fact, it is frequently more than the ship's captains make. And the cost for the monitors presents a huge burden that could easily drive these fishermen out of the herring business, which is why they brought a federal lawsuit seeking a ruling that they were not responsible for paying the cost of these at-sea monitors. However, the real issue here is that in both of these cases, the lower court applied Chevron and deferred to the agency's interpretation, even though there is no way to argue that the provision of the MSA in question is ambiguous. There is a fundamental canon of statutory interpretation. This is expressio unius est exclusio alterius, which translates to the expression of one thing implies the exclusion of others. Now, this is known as the negative implication canon, and in statutory interpretation and construction, this is something that we see that we also encounter and recognize really frequently, not just in statutory and interpretation and construction, but also just in our daily lives. For example, when a car dealer promises a low financing rate to purchasers with good credit, it is entirely clear that that rate is not available to purchasers with spotty credit. And yet, when these cases came before the lower courts, Chevron Step 1 was clear. The meaning of this provision in this statute is unambiguous. That makes this a matter of law, that it would be the purview of the courts to speak to, but however, they still deferred to an agency interpretation, meaning that in these cases, the courts are not doing their constitutionally mandated duty, which is to say what the law is. And as a result, several of the affected herring fishermen have successfully petitioned the Supreme Court to review their case and the specific issue of whether the Chevron Doctrine should continue to be applied by federal courts in situations like these. So, we're going to move on now to discussing the actual oral arguments that took place recently in Loper Bright and in Relentless Inc. Now, both of these cases came before the court addressing the very same issue. And when the court chose to grant cert on Loper Bright back in May, what happened was Justice Jackson recused herself from that case because Loper Bright had actually come before her during her time on the DC Circuit Court, and she had heard the oral arguments from Eric Bollinger, who was an attorney for the Cause of Action Institute, who was also representing Loper Bright Enterprises in this case as well. And this is just standard fare for a judge to recuse themselves in such circumstances. And this is why, several months later, the court would additionally agree to hear Relentless Incorporated versus the Department of Commerce as well, because that case had come to them from the First Circuit, and it would allow all 9 justices to rule on this matter. And since both cases involve herring fishermen and the ambiguity inherent in the MSA as to whether the government can force individual companies to pay for at-sea monitors that they are forced to carry, ultimately, the court would essentially sort of squeeze these two cases into one technically, although they're argued separately. However, the question presented in both cases, both Relentless and Loper Bright, are being decided on the same single identical question presented. And that is whether the court should overrule Chevron or at least clarify the statutory silence concerning controversial powers expressly but narrowly granted elsewhere in the statute does not constitute an ambiguity requiring deference to the agency. Now, I think unfortunately the court denied taking any other questions other than that one, which again I think is unfortunate because both Loper Bright and Relentless Incorporated had second QPs in their initial petition for cert. Now, in Loper, the second QP was whether, under a proper application of Chevron, the MSA implicitly grants the National Marine Fisheries Service the power to force domestic vessels to pay the salaries of the monitors that they must carry. Now, on the other hand, in Relentless Incorporated's second question presented, which this is one that I would really have especially like to see the court take on, what they were asking was whether the phrase necessary and appropriate in the Magnuson-Stevens Act augments agency power to force domestic fishing vessels to contract with and pay the salaries of federal observers that they must carry. Now, the court did actually do something interesting here in these cases. And this is something that I can't, at least personally, ever remember them doing before. Uh, Though, in all fairness, I'm sure they have, but if so, it's something very rare. I can't remember seeing it myself, and that is that they allowed all the amici briefs that were filed initially months ago in the Loper Bright case to be carried over into the Relentless Incorporated case. Now, how this all went down was Relentless Incorporated was heard first, and so these arguments were made before a full bench. And second, after Justice Jackson recused herself, it was then that Loper Bright was argued before an eight-member court. However, when we listened to the oral arguments from the court, the discussion that was going on that day was a very fluid one, and really in most regards, these two sets of oral arguments really felt like one extended 4 hour session, all discussing the same case. So now that we are all up to speed on the cases themselves, I want to now get into discussing the oral arguments because I was truly surprised at the line of questioning that came from the judges. Now, as I mentioned earlier in the show, I have been following Loper Bright ever since around 2021 when this case first came before the district court. And that entire time, I have been both consistent and emphatic that we would not see the court overruling Chevron, and that at best these cases would bring about some very modest reforms in administrative law and in agency rulemaking. However, over these 4 hours over which these oral arguments happened, my position completely flipped. And I am now all but certain that this case will finally be the one that actually overrules Chevron. Now, this is kind of incredible because many people have brought many cases before the court in the past that were seeking to do precisely the same thing. And the fact is that none of them have ever come close. So, this is really, truly a very big deal. And while generally speaking, no one ever likes to admit that they were wrong, this is one time where I am more than happy to admit that I was wrong. The fact is that Chevron was a terrible case that took a sledgehammer to separation of powers, to due process of law, and seriously, seriously undermined the entire system of Article 3 federal courts in a profound way. Now, the first interesting thing that came out of this was during the arguments for Relentless Incorporated, something that came to light was a fact that really, I think, in some senses, made this issue of at sea monitors seem even more unjust and unduly burdensome than they had in the Loper Bright case. Because Relentless Incorporated operates a freezer boat that stays out for something like 10 to 12 days at a time, while in Loper Bright, that company will stay out for 2 to 3 days at a time. And often, Relentless will go out to fish for things other than herring. They will often go out and apparently fish for squid and for butterfish. And what we found out was that even when this company is fishing for things other than herring, they are still obligated to have those at-sea monitors that only regulate herring, and that they are still obligated to pay these monitors more than $700 a day. Now, another interesting point was that while neither party, either Relentless or Loper Bright, ever actually really disagreed with the other on any matter of law, they took two very different angles of attack. Now, Relentless was making a constitutional argument. They were largely focusing on violations of Article 3, in which it is the duty of the judiciary to say what the law is, not administrative agencies. And they also made a due process argument based on the fact that you are in litigation with a party that is telling the judge what the law is, and the unfairness of that should be manifest.
We'll hear argument first this morning in Case 22-1219, Relentless versus the Department of Commerce. Mr. Martinez.
Mr. Chief Justice, and may it please the Court. For too long, Chevron has distorted the judicial process and undermined statutory interpretation. It should be overruled for three reasons. First, Chevron violates the Constitution. Article 3 empowers judges to say what the law is. It requires them to interpret federal statutes using their best and independent judgment. Chevron undermines that duty. It reallocates interpretive authority from courts to agencies, and it forces courts to adopt inferior agency constructions that are issued for political or policy reasons. In doing so, Chevron blocks judges from serving as faithful agents of Congress. It mandates judicial bias and encourages agency overreach. And by removing key checks on executive power, it threatens individual liberty. Chevron also violates the APA. The most straightforward reading of Section 706 requires de novo review of legal questions. Congress put constitutional and statutory interpretation on equal footing, and it required independent legal judgment as to both. As Justice Scalia wrote, the APA's text contemplates that courts, not agencies, will authoritatively resolve ambiguities in statutes. And third, this Court's only justification for Chevron is the implied delegation theory, but that theory is a fiction. There's no reason to think that Congress intends every ambiguity in every agency statute to give agencies an ongoing power to interpret and reinterpret federal law in ways that override its best meaning. In this case, the agency misinterpreted the MSA to force struggling fishermen to pay up to 20% of their annual profits to federal agents. The government says that even if all 9 of you agree with us that the agency's construction is worse than ours, you should nonetheless defer to that construction and uphold their program under Chevron. That's not consistent with the rule of law. If we have the best view of the statute, we should win this case. I welcome the Court's questions.
Now, on the other hand, Paul Clement, who was representing Loper Bright Enterprises, made his case against Chevron, really focusing on issues with the Administrative Procedures Act.
We'll hear argument next in Case 22-451, Loper Bright Enterprises versus Raimondo. Mr. Clement.
Mr. Chief Justice, and may it please the Court, this case well illustrates the real-world cost of Chevron, which do not fall exclusively on the Chevrons of the world, but injure small businesses and individuals as well. Commercial fishing is hard. Space on board vessels is tight, and margins are tighter still. Therefore, for my clients, having to carry federal observers on board is a burden, but having to pay their salaries is a crippling blow. Congress recognized as much by strictly limiting the circumstances in which domestic fishing vessels could be saddled with monitoring costs and capping them at 2 to 3% of the value of the catch. But the agency here showed no such restraint, requiring monitoring on 50% of the trips at a cost of up to 20% of their annual returns. Nonetheless, the court below deferred to the agency because it viewed the statute as silent on the who pays question. There is no justification for giving the tie to the government or conjuring agency authority from silence. Both the APA and constitutional avoidance principles call for de novo review, asking only what's the best reading of the statute. Asking instead, is the statute ambiguous, is fundamentally misguided. The whole point of statutory construction is to bring clarity, not to identify ambiguity. The government defends this practice not as the best reading of the APA, but by invoking stare decisis. That is doubly problematic. First, at issue here is only Chevron's methodology, which is entitled to reduced stare decisis effect. We have no beef with Chevron's Clean Air Act holding, and we could not take issue with its APA holding because it failed to mention that statute. But second, all the traditional stare decisis factors point in favor of overruling Chevron's methodology. The doctrine is unworkable as its critical threshold question of ambiguity is hopelessly ambiguous. It is also a reliance-destroying doctrine because it facilitates agency flip-flopping. So the reality here is the Chevron two-step has to go and should be replaced with only one question. What is the best reading of the statute?
Now, when it comes to the Administrative Procedures Act, this is a statute that we have talked about in other past videos. I think most notably would be my very recent video about SEC v. Jarchese, which would be worth watching if you want to gain a good understanding of what the APA is and why it is important. But really, Loper Bright really helped to highlight the fact that along with Relentless Inc. and these two very separate arguments about the same issue, really drove home the fact that there are a lot of reasons why Chevron is just fundamentally bad. All right, so let's move on to the justices' questions and opinions in the case. And this is, for me, where things got really interesting. It was immediately after Relentless Incorporated had made their opening arguments, and the hearing opened up 2 questions from the justices. And this is precisely what changed my mind about the outcome of this case, because as we go down the line, what we see is that all the justices were asking questions that were essentially predicated on the notion of, well, what happens when we overrule Chevron? And in this sense, the justices here were really giving the game away. Now, it was, to me, immensely encouraging to see the justices focus on wanting to know what happens in the absence of Chevron. Now, this started out right from the very first question, which came from Justice Thomas, who was initially asking, essentially, is there any amount of allowable deference under Article 3?
Mr. Martinez, how much deference is in tension with the judicial role?
I think it's very much in tension, Your Honor.
How much would it require? I mean, your argument is that Chevron deference is problematic. But how do we determine how much deference is too much deference?
I think you've certainly crossed the line when you have a rule that says that we're going to allocate interpretive authority from Article 3 courts to an agency. And so when you've got deference that amounts to that, which is what Chevron deference is, then I think you've crossed the line, because what you've really done is
what I'm asking is, how do we know where the line is? We show deference. There's Skidmore deference.
Sure.
We are deferential in fact finding, et cetera. So I'm just trying to determine whether you're saying that if it's not de novo review,
right,
without any presumptions or deference, then it's problematic.
I think deference becomes problematic when it requires a judge to say that the law means X, when really the judge thinks the law means Y. I think Skidmore deference is not problematic because it doesn't require that. Skidmore deference essentially says, and we would be very comfortable with Skidmore, that because the agency has an important role to play in the process, often the agency has helped draft the statute, the agency has knowledge of the policy context surrounding the statute and its implementation. Of course, courts should pay special attention to what agencies say, but the agency ultimately has to bring its expertise to bear in a way that's persuasive. And if the court isn't persuasive, if the court thinks that the law means X even though the agency thinks the law means Y, then the court needs to go with the best interpretation of the statute, just like it does in every other area of statutory or constitutional interpretation.
Let's suppose.
And here, Justice Thomas and the attorneys for Relentless Inc. Talk a lot about something known as Skidmore deference. Now, this is an important concept, and this is something that we will be returning to a little later in the show to discuss exactly what it is. But moving on from here, next was really Justice Elena Kagan, who was really champing at the bit to defend Chevron. And this was no surprise. She is someone who really likes the idea of leaving these matters of law to technocrats and people who are considered to have expertise in whatever issue a given agency is tasked with controlling.
Well, let me give you a few more examples along the same lines, Mr. Martinez. Is a new product designed to promote healthy cholesterol levels a dietary supplement or a drug?
Sorry, can you give that one more time?
A new product designed to promote healthy cholesterol levels. Is it a dietary supplement, that's a statutory term, or a drug?
I think it would depend on the original understanding of the text of that statute read in context. I think that's a legal question for a court.
You think that the court should determine whether this new product is a dietary supplement or a drug without giving deference to the agency, where it is not clear from the text of the statute or from using any traditional methods of statutory interpretation whether, in fact, the new product is a dietary supplement or a drug. You want the courts to decide that?
Justice Kagan, I think with respect to that question or any other of a legal question, I think what the court would do, they're going to be hard questions, but I think the court would bring all the traditional tools of construction to bear.
They do that under Chevron. We have made clear all the traditional tools. If you can find an answer, that is the answer. So the court is very rarely in the situation in which you're talking where it thinks the law means X and instead it says Y. If it thinks it means X under Chevron, as we've understood it and made clear and reined it in a little bit over these last few years, it's supposed to say X. But sometimes law runs out. Sometimes there's a gap. Sometimes there's a genuine ambiguity. And I don't know. In that case, I would rather have people at HHS telling me whether this new product was a dietary supplement or a drug.
However, I do think that Relentless and Loper both did very good jobs of distinguishing that there is in fact a big difference between law and policy, and that what we are talking about with Chevron is giving these agencies the power to rule on matters of law as well as policy. Now, really, the next to chime in here was Justice Gorsuch, who has been highly critical of Chevron deference, going as far back as his earliest tenure as a circuit court judge. Now, he made a very solid argument on a point that I think is really rarely ever mentioned, but really should be talked about more. Now, he pointed out that he and other appellate court judges see that Chevron is really prone to what is known as agency capture. And this is where the industry that is supposed to be regulated by an agency has really captured that agency, and rather than being regulated by it, really tends to almost control that agency. And what he pointed out was that when we see this agency capture, what we see is the people who are being regulated by it, and there should be no surprise, tend to really like Chevron. And in contrast, he talked about when it comes to issues, or really agencies, I guess, over issues like Social Security or Veterans Affairs or immigration and so forth, which are all administrative agencies where the people who are dealing with these agencies really don't have any power to capture that agency and use it to their own advantage. that these people, and so we're talking about people like immigrants and veterans and people with disabilities, what happens is these people are routinely hurt by the very agencies that they are seeking to get some kind of benefit from.
I want to add as well.
I have another question, though. Chevron, you emphasize, is value neutral, and it'll sometimes favor industries that are regulated and sometimes favor the government. And I can certainly see that in scenarios where we talk about the flip-flop of administrations and new people come in and replace others, and there's a lot of movement from industry in and out of those agencies. I think George Stigler talked about regulatory capture. And I don't worry in a Chevron regime about those people. They can take care of themselves. Okay, there is political accountability. Fine. The cases I saw routinely on the courts of appeals, and I think this is what niggles at so many of the lower court judges, are the immigrant, the veteran seeking his benefits, the Social Security disability applicant, who have no power to influence agencies, who will never capture them, and whose interests are not the sorts of things on which people vote, generally speaking. And there Chevron is almost always, and in fact I didn't see a case cited, and perhaps I missed one, where Chevron wound up benefiting those kinds of peoples. And it seems to me that it's arguable, and certainly the other side makes this argument powerfully, that Chevron has this disparate impact on different classes of persons. And I wanted to give you a chance to respond to that.
Sure, and I have a couple of different reactions to that. One is to say that I, of course, acknowledge that the way that Chevron operates, it gives effect to agency interpretations, even in circumstances where that might be oppositional to some of the categories of individuals that you're identifying. But if it does that in accordance with Congress's intent and wishes, because even my friend agrees that there are certain delegations that Congress can make to agencies and certain gap-filling that agencies can do, at least with the broad and capacious terms. And at that point, it's just putting into effect what Congress decided. So I don't think that there is any kind of fundamental flaw in giving effect to Congress's statutes in that regard.
But you've left open the possibility that a judge, if left to his own devices, would say the fairest ruling is in favor of the immigrant, it's in favor of the veteran, and it's in favor of the Social Security disability applicant. But because of a fictionalized statement about what Congress wanted when it didn't think about the problem, the government always wins.
Well, I think there are a couple of different ways to come at that concern. One is to emphasize, again, that if it's not just that in the exercise of discretion the court would think something is fairer and fill the gap that way, but rather the court thinks actually the reason it's fairer is because I have a sense that Congress spoke to this. I can determine it based on all of the tools. You can resolve that at step one.
But that doesn't work, though, because you've said that it doesn't matter whether Congress actually thought about it. And that,
yes.
And that there are many instances where Congress didn't think about it. And in every one of those, Chevron is exploited against the individual and in favor of the government.
Now, sort of the next person to chime in here was Justice Jackson. And she had what I think is sort of a very odd concern about policymaking. Now, she took a very reasonable position that it should be the democratic elected branches of our government who are making regulatory policy. However, she seemed to believe that it is once Chevron is overruled that this will no longer be the case.
Martinez, what I'm stuck on is what seems to be an assumption in your argument that every question posed with respect to interpreting a statute is a legal one. I see Chevron as doing the very important work of helping courts stay away from policy making. And so I'd like for you to sort of think of it through that lens and help me understand why, if we do away with Chevron's framework, we won't have a problem of courts actually making a policy decision. So Justice Kagan gave you a number of examples. And I think the reason why those examples are hard or why they're ambiguous or whatever is because at bottom they're not asking legal questions. They're asking policy questions. How is it that stationary source is to be defined? That's not really a legal question. I mean, there could be several reasonable ways of interpreting that. And at the end of the day, I think the way I've been thinking about Chevron is Congress has given that policy choice to the agency. And my concern is that if we take away something like Chevron, the court will then suddenly become a policymaker by majority rule or not, making policy determinations. So how can we avoid that?
So we agree, obviously, that courts should not be in the business of policymaking. And I think the whole enterprise of statutory interpretation, when properly understood, is designed to take courts out of policymaking, because what the court is trying to do is act as a faithful agent of what Congress has done and find the best interpretation.
Isn't that what Chevron does? I mean, isn't Chevron step one, even in this very case, asking the question, one, has Congress made that policy determination? So, for example, here, the question is whether or not monitors on the boats have to be paid for by the owner of the boat. I see that as a policy question. Congress could have said yes or no. There's nothing about law really inherently in the question of should the monitors on the boats be paid for by the owners or the government. So step one is, has Congress in the statute answered that question? When we say no, everybody agrees that's not in the statute, then we say the agency can make that determination so long as they do so in a reasonable way. And courts sort of police the boundaries of reasonableness, but whether or not the monitors are paid for is not really a legal question.
I think the question of whether or not the law allows the agency to force the monitors to be paid for by private industry is absolutely a legal question. I agree with you that.
But isn't that the same question as to whether or not, isn't that just another way of saying, can this policy determination be made by the agency?
No, I don't think so. I think the difference is when the policymaker, whether it's Congress or the agency, is sitting there and trying to figure out like what the best policy is, would the world be a better place if industry has to pay for these monitors or not? That's absolutely a policy question.
Okay, so that's the question, right?
But no, because when it comes to a court, the court is not figuring out what the best thing for the world is. The court is figuring out, well, what did Congress actually want here?
But I guess I'm afraid that the court really is figuring out what the best thing in the world is if we look at it through your lens, right? Because if the answer to the question is should they pay for it or not? The agency has a view, and unless we're deferring to that view, I don't see why we aren't overriding the agency's policy prerogative.
The question that the court should be answering is not should industry pay for the monitors? The question that the court should be answering is, did Congress require or allow industry to be forced to pay for the monitors? And that's a very different question. That's the difference between law and policy making. And I think the whole assumption, the whole understanding of statutory interpretation under this court's cases is there's a difference between law and policy making. Judges are there not to exercise force or will. They're there to exercise judgment. They're serving as neutral umpires. They're not players on the field.
All right, so how does that play out under your interpretation? So here, what is the question we're supposed to be answering?
The question you're supposed to be answering is, does this statute require, has Congress required, either required the monitors to be paid for by industry, or has it given the agency the authority to make that decision? And I think that is a legal, both of those versions of that question are legal questions, and the answer is no.
Now, this to me is odd because what she is describing is exactly what we already have under Chevron. Not only are the agencies who get to make this policy not elected, they aren't even appointed by elected representatives. Now, the president gets to appoint the heads of these agencies, but the fact is, these are people who are overseeing the big picture shit. It's people who are several steps removed from any democratic accountability who are actually making policy. And as we have discussed in my recent video about SEC v. Charchesi, these are people who can't even be held accountable by any elected official, even when they screw up badly enough that they should obviously be removed from their post. Now, it is a clear violation of Article 2's Take Care Clause, which says that it is the duty of the president to take care that the laws be faithfully executed. The problem here is that The president has no recourse if the laws are not being faithfully executed as far as administrative agencies go. Now, overruling Chevron doesn't make policy decisions the purview of the court. It makes them Congress's purview, which is how it should be. Because if an agency wants to make a policy where a statute is ambiguous or silent, then it should be up to Congress to amend the statute to make the policy clear. The only role the court would really have is to prevent these agencies from acting where they have no congressional authority to do so, meaning the court will simply be there to make sure the policy is coming from elected officials. Now, sort of next in the line of questioning, we had Amy Coney Barrett, as well as the Chief and Justice Alito. And as I listened to their arguments, their questions really all seem to run together in a weird way for me a bit. Now, Barrett initially started out where Justice Jackson did, asking for further clarification about the distinction between law and policy, and she really wanted to understand where a really clear distinction can be drawn between these two things.
I want to ask you something about your Article 3 argument, too. Justice Thomas asked you what the line is, and, courts all of the time make judgments about whether things are reasonable. But I don't understand you to be disagreeing that things like whether something is, that an agency could be tasked with deciding what was the most feasible, most useful, most reasonable. Well, courts could do that too. So is that a delegation of judicial power that would offend Article 3 in your view to give those kinds of
No, I think the way to think about those kinds of statutory provisions would be that the best interpretation of the statute, given the nature of the word reasonable in context, is to confer a range of discretion on the agency. And so I think a court in that case, if the agency is operating within the range of discretion, that's arbitrary and capricious review. If the agency is sort of operating at the edges, you have to figure out where the guardrails are. That's the legal question. So if the statute says, the agency can pick red, blue, or green, then the choice among those three options is for the agency. But if you have a legal question like, does pink count as red, that's a legal question.
Now, Amy Coney Barrett was also asking how much is Chevron used and how big of a deal will it be when Chevron is gone? Now, this was also, it turned out, really sort of the Chief's main concerns too, at least during the initial case in Relentless Inc. He was really asking, just how much is Chevron used? And he posed this question, of course, first during Relentless, but he also brought the same point up in Loper Bright. And on this matter, I do think that Raimondo and Paul, who are the attorneys for Relentless Inc. and for Loper Bright, both did a fabulous job of getting the point across that, the lower courts use Chevron all the time, but they almost never use it in the way that you people are saying it should be used. And that really is a great point, because it would be one thing if the lower courts were using Chevron, but applying the rigorous two-step process to reach their decisions. But the fact is, they simply don't. And this was a point that was also articulated, I think, especially well by Justice Gorsuch.
For the court to not...
I'm sorry to interrupt, but those are two very different views about what qualifies as an ambiguity you've just given us. One is there is a better interpretation I provided as a court. The other is, but I'm going to defer anyway, given whatever considerations you want to throw into the ambiguity bucket. And that's exactly the problem that your friends on the other side suggest have persisted in the lower courts for 40 years, and why some judges claim never to have found an ambiguity, and other equally excellent circuit judges have said they find them all the time. And it's also why, maybe a dozen or more circuit judges have written asking us to overrule Chevron. And it also may be why one of your colleagues last year said, I don't know what ambiguity means at this lecture. And should that be a clue that something needs to be fixed here? That even the federal government at the podium can't answer the question, what triggers ambiguity? You've given us two different alternatives today, and so many lower court judges who just want to follow whatever we tell them to do faithfully can't figure it out.
Now, the simple fact is that when it comes to the lower courts, they usually paint with very broad strokes and apply no judicial rigor. And if we go back to the opinion from the First Circuit in the Relentless case, what we see is that they there use absolutely no rigor whatsoever. And I think that Raimondo, the counsel for Relentless Inc., did a great job of making that and also making it a larger point with their case as a very relevant example. That really, when we look at the lower court decisions in this case, there was no mention of step 1 or step 2. The government basically said, well, we want more at-sea monitors, and we want them to be paid by the boats who are forced to take them on. And the First Circuit basically just said, well, fuck yeah, it sounds fine to us. Now, there was no scrutiny and no rigor applied by the First Circuit in that case at all, which is really what I would refer to as sort of the modus operandi of the lower courts. And yes, I realize that's not a real word. I like the way I say it better. Fuck off. So, really, what we see in the lower courts is that they constantly claim Chevron deference without applying the Chevron methodology that would be required to actually make this a tenable policy. And then moving on to Justice Alito, he was really seemingly most interested in talking about, well, why do we even have Chevron? Why was it implemented? Why do so many people think this decision was so great? Now, he posed these questions to Ramon Martinez, who was the litigator for Relentless Inc.
Alito?
Mr. Martinez, would you agree that one of the reasons why Chevron was originally so popular was concern that judges were allowing their policy views, consciously or unconsciously, to influence their interpretation of the statutes in question?
Yes.
Why was that fear unfounded? Why do you think now that the fear was unfounded?
Well, I think three things. First of all, I think the fear it's reasonable to think the fear has diminished over time, regardless of what it was then, in large part due to the very salutary developments in the way that this court and the lower courts generally now think about statutory construction. In the old days, there was a lot of reliance on legislative history and on sort of more free-form analysis that I think made it easier for policy considerations to infect the judicial decision-making process. But this court has now made clear that, really we should be text-focused. We should be focused on faithful agency to Congress. So I think that is one difference. I think another difference is courts now have become more appreciative of the fact that we're not just talking about, rules of like judicially made common law about how to interpret statutes. We have the APA here. Justice Scalia was a big defender of Chevron in its original incarnation, but over time came to realize that the APA had text that actually bore on this question. And I think when you're enforcing that text, you come to the same place as our Article 3 argument, which is that courts have to exercise independent judgment.
And he would essentially ask the very same line of questioning to Paul Clement, who was there representing Loper Bright.
Mr. Clement, can I ask you the same question I asked Mr. Martinez about why Chevron was initially popular? People who were very sophisticated and had a deep understanding of how judges decide what a statute means and a deep understanding of how administrative agencies work thought that Chevron would be an improvement because it would take judges out of the business of making what were essentially policy decisions. Now, were they wrong then? And if they weren't wrong, then what, if anything, has changed since then?
So, Justice Alito, I think they were partially right then. So let me say what's changed and what hasn't changed, i.e. what the court missed back in Chevron. What has changed is we've come a long way in statutory interpretation. And, you know, if Chevron was a response to some of the excesses of the D.C. Circuit in the freewheeling days of the late 70s and the use of legislative history, and, oh, by the way, the text of this statute appears in the margin of my opinion, and I'm not going to talk about it again because I'm off to the races. We now, I think, are all textualists. The focus is much greater on the text of the statute. And once you recognize that, you recognize the problem with deferring at a certain point to the agencies. And let's look at the track record of the agencies before this court. If they are so expert, they should be able to persuade you in case after case that they're getting these statutes right. By my count and by the Cato Institute in their amicus brief, since the court last cited Chevron, the administration is batting about 300 in these cases. So expertise is not all what it's cracked up to be.
And again, here is a place where I think really both parties did a very good job of explaining how the modern administrative state that gave rise to Chevron that came out of the 1960s and 1970s was a time when the court was completely untethered by the Constitution and by statutory text. And really, even by the time Chevron comes around in the mid-'80s, which was the later Burger Court, really the court was at best driven by judicial restraint. So the kind of judging that Chevron was meant to correct simply doesn't exist anymore in a court where we now have a majority of justices who claim to be guided by originalism and by textualism, and the sort of court that gave rise to the administrative state where you could just make up policies that wherever you felt like just isn't going to cut it anymore. And here it was Justice Elena Kagan and Sonia Sotomayor were both very concerned about stare decisis and what will happen to cases that rely on Chevron.
Counted, or I think not I, the Solicitor General or someone has given us a list of 77 cases in which the court has used the Chevron approach and interpreted what the law was. Your overruling Chevron puts a question to all those 77 cases.
No, Your Honor. I think
no. Your out is it's stare decisis now.
Right. So
until the agency does something else, and then people can come back because it's not stare decisis anymore.
So I think with respect to the effects of applying normal rules of construction here instead of Chevron, I'd say two things. First of all, the 70 holdings or whatever, the bottom line holdings in those cases would get stare decisis, so they would not be undermined. So there's no convulsive change of the law with respect to this.
And here, this was another point where, after it was made by Kagan and Sotomayor, we would really see actually the chief jump in and echo his own concerns on this very same point as well. You know, do we have to do this all over again? Are all these past Chevron cases going to be a jump ball? And here, I think the obvious answer, and the answer that was given very well by both Relentless and Loper Bright, was simply no. These cases are matters of statutory interpretation. The court has always been very strong on that, and however a statute was defined by the court, that is going to tend to stick. Now, I guess this is perhaps with the exception of Brand X, which was a discussion that came out, which made for a very fascinating side discussion during these arguments. Now, Brand X, for those who may not be familiar, is a case that allows the agency to make one ruling on what the law is, at which point a court can rule on it and say if it is right or wrong. But after that, an agency can totally change their meaning, at which point the case becomes unreviewable because the court already spoke to that matter. So yeah, essentially Brand X actually says that not only can agencies make the law, but they can entirely remake the law. And the court is incapable of doing anything to correct that change, even if it seems likely that Chevron will be overruled. Really, here it's very hard to say what precisely would replace it. However, there is one very likely option, and I want to get back to this because this is something we discussed earlier briefly, and this was something that was discussed extensively during the argument, and this is the doctrine known as Skidmore deference. Now, Skidmore deference is a doctrine derived from a landmark 1944 Supreme Court case known as Skidmore v. Swift. And so in Skidmore v. Swift & Co., what we have is a United States Supreme Court decision holding that an administrative agency's its interpretive rules deserve deference according to their persuasiveness. Now, the court adopted a case-by-case test, which considers the rulings, the interpretations, and opinions of the administrator. And during oral arguments in these cases, Skidmore deference was endorsed by both the counsel for Relentless Inc. and for Loper Bright Enterprises as a reasonable alternative to Chevron that they would both be comfortable with adopting as a standard to review or really to replace Chevron. Now, this case provides, I think, a very reasonable alternative that makes it much harder for people who claim that we should uphold Chevron merely because it represents 40 years of precedence, and they say this regardless of whether the precedent that they are talking about is one of goodness or of badness.
There's a lot of, badness in the world today. I see it in court every day. I've sentenced boys younger than you to the gas chamber. Didn't want to do it. Felt I owed it to them. The most important decision you can make right now is what do you stand for, Danny? Goodness or badness?
But the reason to favor Skidmore deference over Chevron deference is because inherent in Skidmore is the recognition of the crucial distinction between law and policy. It gives the interpretation of law to the courts while giving the prerogative to create policies to administrative agencies, which means that Skidmore naturally deals with the concerns of those who draw the line between law and policy, and when is it best to leave decisions up to the expertise of administrative agencies. And in fact, I actually think the best description of Skidmore as a replacement for Chevron didn't actually really come from the counsel for Relentless or for Loper Bright, but from Justice Gorsuch.
Martinez, I guess I'm struggling to understand what's at stake here, given the questions, because as I understand Justice Kagan's hypotheticals, which are hard ones, that one option would be to say it's ambiguous and therefore the agency always wins. That's what I understood Chevron to mean, at least coming in here today. Another would be to listen carefully to both sides and provide special weight under Skidmore to a co-equal branch of government's views about the law, which one would think we would do anyway, and that they would be considered great weight in arriving at the best answer, and that's what a court would do if there were no interpretive principles advanced by the executive branch, if there hadn't been some sort of rule or adjudication. Is that correct?
I think that's correct, and I think the difference between the Skidmore approach that you just laid out and the Chevron approach is just at the end of the day, once you've considered all the expertise and all the information the agency has to bear.
Who decides?
Who decides? Is the judge persuaded or not persuaded?
Is the judge persuaded at the end of the day with proper deference given to a co-equal branch of government, or does the judge abdicate that responsibility and say automatically whatever the agency says wins.
Right. Even if the judge is not persuaded.
But Mr. Martinez, doesn't
and then
that...
if I might just finish up, what's the effective difference of that? It seems to me that in the first case, when a judge says, here's the law, it's settled. We're done, right? It can be appealed, but at the end of the day, if the Supreme Court of the United States upholds that interpretation, we're finished. Whereas under the Chevron approach, are we finished?
No.
What happens?
I think the agency can overrule what the court said. The agency can overrule what itself said. I think that's a very strange thing, that in every other area of statutory interpretation, we understand the law to have one fixed meaning, and the goal is to try to figure out that fixed meaning. But Chevron, by design, creates this world in which the agency is because there's this zone of discretion, the agency in ambiguity, the agency can kind of flip-flop and then force courts to flip-flop with that.
And I'm struck on that score by the Brand X case, which involved broadband, in which this court said, okay, agency, you automatically win with respect to one interpretation of the Bush administration, I believe it was. And then, of course, the next administration came back and proposed an opposite rule.
Right.
And then the next administration came back and flipped it back closer to the first. And as I understand it, the present administration is thinking about going back to where
That's exactly
right.
That's exactly right, Justice Gorsuch, and I think it plays up the real problem. Chevron really is a reliance-destroying doctrine. Imagine if you're a person or a regulated entity and you're trying to figure out what the law is. You should be able to rely on the best interpretation of the law and not have to, check the CFR every couple of years to see if the law has somehow changed, even though Congress hasn't acted.
And that's the delta between Skidmore and Chevron.
I think that's right. I mean, Skidmore, I think, would allow for courts to give meaningful weight and consideration to persuasive opinions by agencies. The only thing Skidmore doesn't do is require a court to give up its ultimate interpretive say and defer to an interpretation that is not persuasive.
Now, at this point, I think this really brings me to one of the most important points I have to make here. That is that despite the chicken little attitude to overruling Chevron that a large percent of Americans seem to believe in, this really isn't nearly as radical a move as they claim. The fact is, these companies have never even contested the law forcing them to carry at-sea monitors on their boats. All they are asking the court to do here is recognize that the Magnuson-Stevens Act puts the burden of cost onto NOAA, the agency, and not to the individual herring fishing boats. Now, this again, using the negative implication canon, is simply facially true. And this is according to the plain meaning of the text of the statute, which is, of course, further reinforced by the fact that this is how the Magnuson-Stevens Act funded at-sea monitors on herring fishing boats for over 20 years. And crucially, when that change was made, it was not because of a statutory amendment. The agency just wanted to read the statute in an inconsistent manner from the actual text of the law. Now, if that is the case, and it is, all they need to do is get a statutory amendment from Congress shifting the cost of at-sea monitors to herring boats. And if they can't achieve that through the democratic process, that's their problem, not the small businesses who are struggling to simply earn a living. And I also want to stress here that no one is asking the court to categorically deny deference to administrative agencies. They merely propose we replace it with Skidmore, which gives agencies free rein to make and enforce policies in accordance with the lawfully granted statutory powers granted by Congress, while simply at the same time respecting the constitutional authority of Article III courts. However, despite my fairly confident opinion now on the outcome of this case, I have to admit there is still a lot up in the air. The fact is, it is very hard to say exactly how a case like this will shake out. But the wording of the question presented and the hesitation that we saw from some of the conservative justices tend to have, when it comes to important and controversial cases like this, I think means that it's still possible we ended up getting something of a muddled, middling opinion. And really, all it would take would be some hesitation from the chief about the dangers of what Sandra Day O'Connor referred to in the Casey case as the jurisprudence of doubt, which is just a fancy way of saying that even when stare decisis clearly conflicts with the original meaning of the Constitution or with a textualist interpretation of a statute, making stare decisis objectively wrong, even when all parties recognize it's wrong, maybe we should say it's right anyway. Now, such a determination by the chief could very easily prompt Justices Kavanaugh or possibly even Justice Barrett to lose their nerve and to go along with Roberts on a have-to-bay construction. Now, to be clear, again, going off the oral arguments, I think it is more likely than not that we are seeing that even those justices I just mentioned are ready to overrule Chevron. However, I do want to cover all reasonable possibilities, and I think it is worth pointing out that that is a reasonable possibility, and even actually very briefly sort of revisiting the two-part nature of the question presented that the court granted review on, because while they only granted review on one question presented, when you look at it carefully, it actually breaks down into two separate questions. And this is the exact text of the question presented, simply split up. So what it says is whether the court should overrule Chevron or at least clarify that statutory silence concerning controversial powers, expressly but narrowly granted elsewhere in the statute, does not constitute an ambiguity requiring deference to the agency. And I suppose I do want to point out that when it comes to the government's argument here, and it was made by the Solicitor General Elizabeth Prelogar, despite the fact that the position that the Solicitor General was defending was entirely incorrect, I have to very much give credit to her, Elizabeth Prelogar. She is an incredibly gifted litigator, and she did a damn good job of defending her position. So, ultimately, why should Chevron be overturned? What will this mean? Really, what this will mean is that when technocrats want to claim some new power, they will not be able to simply say, well, how do we get around the power of Congress? How do we use ambiguity to create a de facto law the way we want it to be? Because now, all they have to do, under Chevron, is show the courts that what they want to do is a reasonable interpretation of the words, or that the statute doesn't speak to the issue, which means that it is up to them, the agency, to decide how to enforce those laws. And I believe without Chevron, a lot of bad and oppressive agency regulations are simply not going to even be tried because they will know in advance that they won't fly. Now, the simple fact is that Chevron supports bad government in all three branches. It allows Congress to write ambiguous laws because they see a lack of clarity as a way to get things done that would never fly if they actually had to spell it out in the law. And this to me is why Justice Jackson's concerns about democratic accountability seem so misplaced. It is the Chevron regime itself that allows the Democratic branch to act without accountability. And really, it's even more damaging to Democratic accountability under Chevron because when Congress writes an ambiguous law, hoping the agency will run with the ambiguity and do something that could never be done if they had to pass a law in which they spelled out the policy they wanted, when that policy becomes unpopular, that gives Congress a chance to completely shirk responsibility for that bad law by simply saying, hey, look, I don't like that. That's sure not how I wrote that law, you know? And this makes it very easy for them to avoid accountability in the eyes of their voters because they now have a certain plausible deniability of their role in creating these bad laws by delegating that responsibility to anyone besides themselves. Now, additionally, Chevron allows the executive branch to act badly. We just have to look at another case that I have been following here on this show, and that is Cargill v. Garland, which actually, that was its name when it went through the circuit court. It's now going to the Supreme Court this term as Garland v. Cargill, and that's another case that I am following in my Supreme Court roundup. But just sort of to sum it up here, the problem is that this case didn't really begin with Merrick Garland or with Joe Biden, as the name of the case might suggest. This case began with Trump, who, and this is something that I can't say enough, was one of the most anti-gun presidents ever. I know a lot of Trump supporters don't like to hear that, but it's simply true. He was one of the most anti-gun presidents ever. Now, the problem here was that Trump used administrative agencies to limit your Second Amendment right by telling the ATF that they can simply say a bump stock makes a gun shoot faster. Therefore, a reasonable interpretation of the law is that a bump stock is basically a machine gun. Now, this is an obviously improper reading that I have debunked in several videos, and if anyone watching doesn't understand why this is a problematic argument, I will link those videos on the show notes page for this episode. Please go watch them. Now, what happens then is Merrick Garland comes into power and says, well, if a bump stock is a machine gun, then a pistol brace is similar to a bump stock. So even though all a pistol brace actually does is stabilize the firearm by limiting its recoil, which in no way could in any sense possibly be construed as making a gun shoot faster, Merrick Garland says, well, that's no problem, as far as he is concerned, because a pistol brace is kind of like a bump stock, and because a bump stock is kind of like a machine gun, we're now going to ban pistol braces because they are machine guns. This is the kind of shit that is allowed to fly when Congress writes ambiguous laws and agencies can use that ambiguity to make something that says nothing say anything they want it to. And this also gets back to, I think, kind of a point that Neil Gorsuch made earlier that we were talking about in this video, how as different administrations come into office, policies constantly keep changing, and you can't understand what a law means by looking at the text of the statute. You have to look at the ever-changing Code of Federal Regulations that are the agency interpretations of that statute. And it's bad when it happens as Justice Gorsuch described, where one administration comes in and they make a law say something particular, and then another administration comes in and they take the same law and they make it say the exact opposite what it used to. And we have the same law just going back and forth between competing, completely contradictory meanings. But what we can also find here with Chevron, as is demonstrated by this case, is that what can happen is that we enter into something of a suicide pact where one administration comes in and they find a law and they make it say something completely ridiculous and unlawful that is clearly a violation of the Second Amendment. And then, despite the fact that people will insist that, Donald Trump and Joe Biden are the exact opposite and they represent the opposite of each other in every single way, what we see is that behind the scenes, they use this ambiguity to build off the infringement of your rights and the misapplication of a statute from the last administration, and they make an unjust interpretation more unjust with their own unjust interpretation. This Chevron doctrine makes judges lazy as well. We've talked about why it makes Congress lazy, why it makes the executive branch lazy, if not also sometimes evil, but it makes judges lazy as well, because they don't do everything they have to do to determine what the law says. As we have discussed, it is very common for appellate judges to apply neither of the supposedly rigorous two steps of Chevron's judicial test. Just as we saw happen with the First Circuit in the Relentless Inc case, they're often completely comfortable just saying, fuck rigor, let's let the agencies do whatever they please. And in this way, Chevron makes for lazy courts. And this is why getting rid of Chevron will force every branch of government to be more rigorous and more accountable, which, if the court gives Chevron the death blow that it deserves, will, I believe, be proven soon enough when Chevron finally goes the way of the dinosaurs, which is to say, a very quick and painful death that will be entirely necessary to make a place on Earth for a new era of human flourishing. That's really all I got for you guys here today. Thank you so much for tuning in to Legalese. And if you would please just take a moment and do all of those things that help to trigger Al Gore's rhythm. If you would, if you liked the episode, hit the like button. If you disliked it, hit the dislike button. Definitely leave me a comment. Let me know what you thought about the video. I really do always love to hear your guys' comments on the topics we discuss here. And of course, make sure to subscribe to the show so you always find out when I have new videos out. And until next time, this has been Bob for Legalese, talking about the death of Chevron deference. And of course, as always, Carthago delenda est.
Motherfucker, like Freddie Mercury, motherfucker. I got a trunk full of amps, motherfucker. I got a trunk full